I stood outside the courthouse in Phoenix, watching the morning sun turn the glass and concrete building into a wall of blazing light. My hands were shaking, not from fear exactly, but from the unbearable weight of what I was about to do. I was 32 and I was suing my own father. The family textile business had been my mother's legacy. She had started the company in the late 1990s, growing a tiny operation into a respected supplier of fine fabrics to boutique hotels and upscale restaurants across the Southwest. She taught me everything: how to read a bolt of cloth, the difference between warp and weft, how to spot a supplier who cut corners. When she died 3 years earlier, she left a will that split ownership, half to me, half to Gregory, with the explicit understanding that we would run the company together. That understanding lasted 6 months. Gregory had always been charming in the way predators are charming. Slick, persuasive, and practiced. My mother used to call him her silver-tongued devil, a teasing phrase she used with a laugh, never imagining how literal it would become. He had spent most of their marriage in sales, always traveling, always with a story and a trinket from some other city. My mother ran the business. He reaped its comforts. After she died, he moved into the executive office as if he had built the place himself. Within weeks, he began to remake the company in his image. He brought in his girlfriend, Veronica, barely older than me, and installed her in a senior management role despite her lack of experience. He renegotiated contracts without consulting me, severed long-standing supplier relationships my mother had cultivated for decades, and diverted company funds toward side ventures that had nothing to do with textiles. I tried to work with him. I scheduled meetings, prepared presentations, and brought data showing how his changes were collapsing margins. He smiled through every presentation, nodded at the right moments, and then did exactly what he wanted. 8 months before the trial, I discovered a loan taken out against the company using forged documents that bore my signature. When I confronted him, he laughed, an actual easy laugh. "You think you understand business because your mother left you some papers," he said. "This company needs real leadership, not a girl playing dress-up in her dead mother's shoes." That was when I knew he would take everything and smile while doing it. I hired a lawyer, Douglas Caldwell, recommended by a friend who had been through a messy dissolution. Douglas read the will, examined the documents, and told me we had solid grounds. The will was explicit. The forged papers were provable. I filed suit 3 months before the date I stood outside the courthouse. Gregory responded the way he always did. He gathered a firm of slick lawyers, launched a counterattack, and waged a campaign of character assassination. They accused me of mental instability and theft, ridiculous assertions, but they muddied the waters. The case moved at an odd pace. Gregory pushed for an early trial date. His team looked supremely confident. Then Douglas discovered the judge assigned to our case, Harrison Whitmore, an old friend and golf partner of my father's. Douglas filed for recusal, and the motion was denied. Whitmore insisted his friendship would not affect his judgment. Inside the courtroom, everything felt both too small and horribly exposed. Judge Whitmore presided with the measured demeanor of someone who had been in charge for decades. My father sat at the defense table in a navy pinstripe suit that cost more than my car. He glanced at me once, neutral, composed, then whispered to his lead attorney and chuckled. I sat with Douglas, jaw clenched, hands folded where no one could see them. Douglas began with a precise opening: my mother's will, the timeline of exclusion, the forged loan documents. He built a case that should have been straightforward. Vincent Marlowe, Gregory's lead counsel, answered with the ease of practice spin. My father had managed the company diligently. The loan was properly authorized, and the plaintiff, me, lacked the temperament for leadership. He painted me as an emotional, grieving daughter grasping for control. The trial crawled through witness after witness. Douglas called suppliers, longtime employees, and accountants who testified to my mother's intent and to the unusual decisions Gregory had made after her death. They described missed invitations to meetings, proposals left unanswered, and invoices rerouted. The evidence was meticulous, but it felt like the room was tilted away from us. Whitmore interrupted our witnesses with pointed questions and allowed my father's witnesses uninterrupted accounts that harmonized with his narrative. When my father took the stand, he was at his most polished. He spoke of my mother with tenderness, recasting himself as co-founder rather than a spouse who had benefited from her labor. He framed his actions as protection, protecting the business from a daughter who, in his telling, was too sentimental and too inexperienced to steer a complex company. "I love my daughter," he said, looking at the judge with slow, perfect sincerity. "But love doesn't make you fit to run a business." Douglas cross-examined him on the forgery, the loans, and the redirected funds. Gregory answered each question with plausible deniability. Maybe my signature looked different that day, maybe a decision had to be made quickly, maybe the side projects were legitimate attempts to diversify. Judge Whitmore listened with a patient, almost indulgent expression, occasionally asking follow-ups that seemed to rescue Gregory's narrative. Nearly everything we presented was met with that same judicial cool. When Douglas called a forensic document expert on the second day, the witness, credentialed and steady, explained in clinical detail why the loan documents weren't signed by me: pen pressure, stroke patterns, and inconsistencies beyond natural variation. Vincent's Cross seemed prepared. He asked the expert about natural variation in signatures, underscoring that stress or haste might alter handwriting. The judge nodded as if these qualifications somehow dissolved the proof. At lunch on that second day, I sat alone in a small park near the courthouse and thought about my mother. She'd been fierce and brilliant and impossibly kind. On her deathbed, she had squeezed my hand and told me to be strong and to never let anyone steal what was mine. I felt I was failing her. A text from an unknown number broke the quiet. "I heard about your trial. Your father is a fraud. I can prove it. Are you interested?" It could have been a trap, a scam, or worse, I answered. The reply claimed the sender had once worked with Gregory and possessed records, bank statements, emails, and recordings, exposing his hidden ventures and the siphoning of funds. We arranged to meet that evening. Helen arrived at the coffee shop late, eyes guarded. She said she had been an accountant for some of Gregory's side projects 5 years earlier. He had paid her to keep quiet. When my mother fell ill, he stopped paying. She'd kept copies of records as insurance. She slid a manila folder across the table. Inside were bank statements referencing shell accounts, emails about property purchases unrelated to textiles, and a printed transcript of a recorded phone call in which Gregory laughed about manipulating business partners who trusted him. She'd waited because she was afraid. Now she wanted to make it right. The documents were messy but damning. Some recordings might be legally contested, but the financial records were public and traceable. She handed me a stack of screenshots and PDFs and said, "This is everything I have." I leafed through them with trembling hands. A payment labeled as a consulting fee grabbed my attention. $75,000 paid 3 years prior to a company called Whitmore Advisory Services. The payee's name matched the judge's son. I stayed up until 3 in the morning, pulling public records and hunting for anything connecting my father to Judge Whitmore. The judge's career, on paper, was impeccable. Decades on the bench, civic boards, a family with children and grandchildren. But property transactions told another story. A vacation home in Sedona had been sold by an LLC that, when traced through layers of filings, led back, indirectly, to a holding company in which my father had a stake. The sale occurred shortly before a case involving one of my father's associates came before Whitmore and was decided favorably. The more I dug, the more the trail suggested not mere coincidence but a pattern. Payments to companies tied to the judge's family, property dealings, and the timing of favorable rulings. Alone, each item might look innocent. Together, they were troubling. I made screenshots and organized the documents Helen had given me. The $75,000 consulting fee to Whitmore Advisory Services, the Sedona property sale, and the favorable timing of rulings formed an ugly constellation. When I told Douglas early the next morning, he read the documents and grew quiet. "This is explosive," he said. "If we present it, we could force a recusal. But we must be careful. If we make claims we can't substantiate, we risk sanctions and losing credibility. He was right. Accuse a judge of corruption without airtight proof, and the court will not look kindly on you. We needed a strategy. We decided not to blurt accusations. Instead, Douglas would weave the facts into closing arguments, pointing to irregularities and conflicts of interest without naming the judge directly, forcing the court to confront the troubling connections. If the judge moved to dismiss, we would seek permission to present our evidence and, if necessary, request recusal formally with the documents organized and corroborated. The courtroom that morning felt taut with possibility and peril. When it was time for closing arguments, Douglas was calm and surgical. He laid out the arc: my mother's explicit wishes, Gregory's exclusionary conduct, the forged loan, and the pattern of diverted funds. Then, with deliberate care, he referenced irregularities in how the trial had moved forward and inconsistencies in financial disclosures related to Gregory's side ventures. He didn't name Whitmore Advisory Services, but he described a pattern of payments and relationships that raised legitimate questions about impartiality. The judge's reaction was small, an imperceptible tightening around his eyes. Vincent rose and countered with theatrical outrage, accusing us of smearing a respected member of the judiciary to distract from a weak case. He insisted the documents were irrelevant and that any insinuation of impropriety was baseless and improper. Whitmore called for a brief recess and retreated to his chambers. The wait felt endless. When he returned, he spoke measuredly, trying to appear above the fray. He acknowledged that the documents raised questions, but declared they did not, in his view, demonstrate a direct conflict requiring recusal. He said he would continue to preside, assuring the room of his ability to be impartial. Douglas asked to address the court, to present the documents formally, and request a recusal at that time. Whitmore hesitated, then allowed Douglas to outline the sources of the documents and their relevance. I watched the judge as Douglas spoke, and for the first time I saw color drain from his face. He asked for clarification about the $75,000 payment. When Douglas pointed out the company name and the public record linking it to the judge's son, Whitmore's fingers tightened on his notes. Then something shifted. The court clerk entered a sealed envelope into the record, an ethics inquiry request from a third party that had arrived overnight, asking for investigation into possible judicial misconduct. The timing was uncanny. Vincent exploded, calling it a fabrication. Douglas calmly requested a short continuance to allow both parties to examine the new material. Whitmore agreed under protest, but his manner had changed. He was no longer the imperturbable arbiter of before. We left the courthouse that day with nothing decided and everything altered. The trial had been paused. A separate inquiry had been triggered. In the days that followed, the press sniffed at the edges. Little mentions at first, then harder questions. Some of Gregory's allies recoiled. People who once smiled at him began to hesitate. In the weeks after, life ran on two tracks: the legal machinery grinding forward and the quieter work of reorganizing my life. I spent mornings in depositions, afternoons tracing transfers, and evenings on the phone with Helen, corroborating details. She was terrified and resolute. Each time she spoke, I heard the tremor of someone who had kept dangerous secrets too long. We arranged for her to provide a sworn affidavit and to deliver original records to my lawyer. Douglas became more than counsel. He became the steady hand I leaned on. We built a binder with bank records, emails, property filings, forensic signature analysis, Helen's affidavit, and the chain of transactions linking Gregory to Whitmore-linked entities. We drafted motions to survive cross-examination and prepared public statements emphasizing facts. Gregory's circle shifted. Veronica retreated. Suppliers who had once accepted his reassurances began to ask questions. Former employees reached out with memos and internal notes that corroborated Helen's documents. The scaffolding of deniability my father used began to creak. There were nights when despair returned. The smell of my mother's desk polish would catch me unexpectedly and undo me. I would sit with her ledger open, tracing her marginal notes with my finger. Those small rituals tethered me. The fight became about honoring the woman who believed in fairness and hard work. When a preliminary ethics inquiry announced the judge's conduct warranted a deeper review, it felt like the system had acknowledged the seriousness of the questions. The case remained unresolved for now, but scrutiny shifted the balance. My father had to justify transactions beyond private dinners and whispered assurances. I still do not know how it will end. There may be appeals, settlements, and investigations that stretch for years. There will be betrayals and painful truths. But in that uncertain chapter between debt and closure, I learned to claim space in a house my mother had built and to keep my voice. You will speak calmly and factually, presenting the evidence without direct accusations. Let the implications speak for themselves. I felt nervous and energized at the same time. The courtroom air tasted like old paper and coffee. My pulse was steady in my throat. Douglas smiled grimly beside me. Then we have enough to file an immediate appeal with grounds for judicial misconduct, he said quietly. This becomes a much bigger case, one that attracts attention. Judges do not like that kind of attention. His voice was flat but certain. It steadied me. We walked into the courthouse together. My father sat at the defense table, relaxed and confident as if he were taking a seat at a private club. When he saw me, he smiled, a small, practiced curl of his lips. He thought he had already won. The courtroom clock read 9 a.m. as Judge Harrison Whitmore called the court to order with his usual solemnity. We will proceed with closing arguments, he announced. Counsel for the defense, you may begin. Vincent stood and delivered his polished summation. He recast the entire dispute as the melodrama of a grieving daughter who lacked practical business sense and blamed her failings on her father. He praised Gregory's decades of experience and framed his actions as stewardship, protecting the company his late wife had built. He spoke with the confidence of someone who had spent a career spinning narratives into verdicts. Every sentence was a distortion, each concession of fact a rearrangement to fit his story. I sat still, hands folded, face neutral, because any visible reaction would be catalogued and used against me. When Vincent finished, Judge Whitmore nodded appreciatively. Thank you, counsel. Plaintiff's counsel, your closing argument. Douglas rose with the calm of someone who had rehearsed this 1,000 times. He walked slowly, measured, hands behind his back. Your Honor, he began. This case is fundamentally about honoring the wishes of a woman who devoted her life to creating something meaningful. Helen Summit built Summit Textile Company through decades of work. Her will explicitly divided ownership equally between her husband and her daughter. That division represented her intent and her trust that both parties would steward that legacy responsibly. He paused to let the will's plain language settle. The county clerk's copy lay on the exhibit table, an unimpeachable artifact of my mother's voice when she could still speak for herself. Douglas continued. The defendant has, through action and omission, violated that trust. He systematically excluded the plaintiff from business decisions despite her legal ownership. He renegotiated contracts unilaterally, severed long-standing supplier relationships, diverted company funds to unrelated ventures, and, most egregiously, secured a loan using documents bearing a forged signature purporting to be that of the plaintiff. Judge Whitmore shifted in his seat. He already wore the expression I had seen throughout the trial, the polite skepticism reserved for inconvenient evidence. Counsel, he interjected, we have conflicting testimony about those signatures. Douglas looked at the judge without flinching. We presented a forensic document analyst with long-standing credentials who testified those signatures could not be mine. The statistical analysis of pen pressure, stroke order, and letter formation shows patterns inconsistent with my client's authenticated signatures. The defense's alternative explanations have been inconsistent and self-serving. The evidence is what the evidence is. His voice carried the authority of someone who trusted facts more than rhetoric. Douglas took a more deliberate tack. Then, moving from the specifics of the forgery to the larger concern I had feared voicing. Your Honor, he said, softer now, we are not merely asking this court to accept our factual claims. We are also compelled to note a pattern in how these proceedings have unfolded. Interruptions of plaintiff witnesses, leeway given to defense testimony, and the manner in which certain evidentiary objections have been resolved. The pattern gives us concern about the fairness of this forum, the courtroom inhaled. My father leaned forward like someone who had been surprised at a joke and was trying to regain control of his posture. Vincent's eyes narrowed. He recognized danger. Judge Whitmore's voice tightened. "Are you questioning the impartiality of this court, counsel?" Douglas met the judge's gaze squarely. "We are observing behavior that, when combined with other information recently discovered, creates an appearance of impropriety that demands investigation. We did not come into court today intending to make a scandal. We wanted a fair resolution on the merits. But out of an abundance of caution and respect for the integrity of these proceedings, we feel obligated to bring certain facts to the court's attention." Whitmore's complexion changed. For the first time in my memory, he looked as if the weight of something greater than the case itself had pressed on his shoulders. "What facts are these?" he asked. Douglas glanced at me, a quick question in his eyes. I nodded. Standing felt like a decision of its own, an act of exposing the rawness of betrayal and the brittle architecture of power. "Your Honor," I said, my voice steady even as my knees trembled, "I have financial records showing that my father transferred $75,000 to a consulting company owned by your son 3 years ago. I have property records indicating that you purchased a vacation home through an LLC partially owned by my father at a price that appears favorable. I have organized these transactions into a timeline that corresponds with several favorable rulings issued by this court in matters involving my father's associates." The silence that followed was cavernous. Air felt thicker. People stopped moving almost imperceptibly. The court reporter's fingers stilled above the keys. Judge Whitmore's face flushed, then paled. My father's jaw tightened to a degree I had never seen outside of a rare private fury. Vincent, who had been the picture of composure moments before, now leaned forward and mouthed quick, clipped phrases to his client. "This is a serious allegation," Whitmore said slowly, eyes darting toward the courtroom doors as if seeking an escape hatch. "You have not." "We do," Douglas interrupted. "We do have documentation. We did not want to make these facts public without giving the court the opportunity to address them appropriately. We can submit them under seal if that is the court's preference, but they are documented: bank transfers, corporate filings, and public land records. We believe they merit examination." Whitmore's manner hardened. "You are making vague insinuations that could impugn the reputation of members of the judiciary. If you cannot substantiate these claims, I will consider sanctions." Douglas, who had predicted both the danger and the stakes, was unflappable. "We are prepared to put our documentation into the record, Your Honor. This is not an effort to impugn, but to protect the integrity of this process." "Approach the bench," Whitmore ordered. Vincent and Douglas walked to the bench and spoke in hushed tones. I could not hear their exchange, but I watched the micro-expressions. Vincent's face flickering between anger and alarm, Douglas's composed intensity. When they returned to their tables, Whitmore declared, "We are going off the record." The room exhaled when the reporter stopped. Then Whitmore turned to me. "Miss Julia," he said in a voice that had tried and failed to sound detached, "do you believe you have evidence of impropriety involving this court?" "Yes, Your Honor," I answered. I felt the words expand in me, no longer just a claim but a call. I handed my phone to Douglas so he could present the files on a secure device. He filed them with the clerk under seal while Vincent protested that we were manufacturing a sideshow to distract from a weak claim. An envelope slid into the record. At an almost theatrical moment, a separate ethics complaint filed overnight by a third party who had requested an investigation. Its arrival felt less like coincidence than inevitable consequence. The court recessed for an hour while Whitmore reviewed the new materials. The halls outside the courtroom swelled with whispers. I sat in a cramped conference room with Douglas for what felt like an eternity. He read the documents with a gravity that cured the last of my hesitation. "This is explosive, Julia," he said, almost whispering. Not because he wanted to hide, but because he respected the fragility of what would come next. If what these records suggest is true, this moves beyond civil litigation into potential criminal conduct. Federal authorities could become involved. The judge, your father, potentially others. Careful surgical steps must be taken. My phone buzzed again, a text from Helen. I had told her what we planned to do in broad strokes. She had warned me to be cautious. Her message arrived in halves, congratulations and a cold warning. She said she had helped set up the Shell consulting company that received the payments and that she had copies of records showing at least 8 payments over several years totaling more than $400,000. The numbers hit me like cold water. This was not a single lapse of judgment or an awkward business deal. It read like a pattern of systematic bribery. When we returned to the courtroom, the tenor had shifted palpably. Whitmore appeared older, as if the hours had taken years. He cleared his throat and addressed the room with a tremor he tried to hide. After reviewing the materials submitted, I have determined that there are sufficient concerns regarding potential conflicts of interest to warrant further examination, he said. In the interest of preserving the integrity of the judiciary, I am declaring a mistrial. This matter will be reassigned to another judge, and proceedings will commence anew. Vincent exploded in protest, calling the move unnecessary and accusing us of manufacturing a mistrial on flimsy grounds. Whitmore cut him off. The decision is made, he said curtly. This trial is over for now. Parties will be notified of reassignment within 48 hours. He paused, then looked directly at me. Miss Julia, for the record, I have always strived to conduct myself with integrity. Any suggestion to the contrary is deeply offensive. You will be investigated, I said simply. I have documentation of 8 separate payments to your son's company totaling over $400,000 over the past 5 years. If you have acted with integrity, this inquiry will show as much. The color drained from Whitmore's face. He opened his mouth, closed it, and left the courtroom without another word. My father rose slowly, not in the practiced, patronizing way he'd used for months, but with the unsettled gait of someone realizing the chessboard had shifted. He stared at me with an expression I had only ever reserved for an enemy, narrow, cold, and full of contempt. You have no idea what you have done, he hissed. I know exactly what I have done, I replied. I stopped you from stealing my mother's legacy. He left the courtroom flanked by his lawyers. His departure was a retreat more than an exit. I felt nothing like triumph, only a steady, cold satisfaction that the first domino had fallen. Douglas put a hand on my shoulder, firm and encouraging. The hard part is not over, he said. But you did what needed to be done. Outside the courthouse, the air had cooled. Reporters gathered like birds waiting for a dropped crumb of news. The case would now split into parallel tracks, civil, ethical, and potentially criminal, and the business that had always been my mother's life would be frozen in the legal gears for an unknown span. There would be consequences, collateral damage, and reckoning. I thought of my mother's ledger and the small scrawl she left in the margins of her accounting book. Protect what you build. Protect who you are. I folded that instruction into my chest like armor and stepped forward, ready for whatever came next. Douglas's words echoed in my mind as we entered the courthouse. Speak calmly and factually. Present the evidence without accusation. Let the implications speak for themselves. I felt both nervous and electrified. What if the judge still ruled against us? Douglas gave a grim smile. Then we file for immediate appeal, judicial misconduct. This becomes a much bigger case. Judges don't like that kind of attention. We walked through the heavy doors together. My father was already seated at the defense table, relaxed, confident. When he saw me, he smiled faintly, the smile of a man certain he had already won. At exactly 9 o'clock, Judge Whitmore entered. We will proceed with closing arguments. Counsel for the defense, you may begin. Vincent rose and launched into his polished performance. He painted our case as a family squabble blown out of proportion by an ungrateful daughter who misunderstood business and blamed her failures on her father. He described Gregory Summit as a devoted husband preserving his late wife's legacy. patiently trying to guide a misguided child. Every word was a distortion, but I sat motionless, my expression calm, hands folded. When Vincent finished, Judge Whitmore nodded appreciatively. "Thank you, counsel." Plaintiff's closing argument. Douglas stood. His voice was calm, deliberate. "Your Honor, this case is about honoring the wishes of a woman who built something meaningful. Helen Summit created Summit Textile Company through decades of hard work. Her will divided ownership equally between her husband and her daughter. That was her wish, her right." He walked to the center of the courtroom, hands clasped behind his back. "The defendant has systematically violated those wishes. He excluded the plaintiff from business decisions despite her legal ownership. He made unilateral choices that damaged the company's relationships and profitability. Most egregiously, he forged documents to secure a loan, using his daughter's signature without consent." Judge Whitmore shifted in his seat, skeptical. "Counsel, we've heard conflicting testimony about those signatures. Our forensic expert, whose credentials are impeccable, stated unequivocally that the signatures were forged," Douglas replied evenly. "The defendant's explanations have been inconsistent and self-serving. The evidence speaks for itself." The judge's face tightened. He wasn't convinced, or didn't want to be. Douglas pressed on. "This court has a duty to uphold the law and protect legitimate property rights. Julia is not asking for charity, only for what her mother intended, what she's earned, and what is legally hers." He paused. "But there is something troubling about these proceedings. Throughout this trial, we've seen irregularities. Plaintiff's witnesses have been interrupted or doubted. Defense witnesses have been allowed to speak unchecked. Expert testimony dismissed, anecdotal claims accepted." The judge's eyes hardened. "Counsel, are you questioning this court's impartiality?" "I'm noting a pattern that gives us concern," Douglas said quietly. "A pattern that suggests potential bias." The air grew heavy. My father sat forward, his composure faltering. Vincent's posture stiffened, sensing danger. "That is a serious accusation," the judge said coldly. "Do you have any basis beyond dissatisfaction with my rulings?" Douglas looked back at me. I nodded. "Your Honor," he began, "we've recently become aware of information raising questions about potential conflicts of interest, information suggesting a pre-existing relationship between yourself and the defendant beyond casual acquaintance." "Have already addressed this," the judge snapped. "Mr. Summit and I are social acquaintances. That does not constitute a conflict of interest." "The relationship appears more substantial," Douglas replied. "We have documentation showing financial transactions between entities controlled by the defendant and entities connected to your family." The temperature in the room seemed to drop. My father went rigid. Vincent leaned toward him, whispering urgently. Judge Whitmore's face flushed. "What exactly are you implying, counsel?" "I'm not implying anything," Douglas said. "We discovered information that creates an appearance of impropriety. Out of respect for the court, we chose to raise it here first." "This is outrageous," the judge said, his voice trembling. "You're making vague accusations. I could hold you in contempt." "We have evidence, Your Honor. We preferred not to present it publicly without giving you a chance to respond, but we are prepared to submit it to the record." The judge studied Douglas for a long moment, calculating. "Approach the bench." Douglas and Vincent stepped forward. They spoke in low voices for several tense minutes. Vincent's face turned pale. The judge's jaw tightened. Finally, the judge looked at the court reporter. "We are off the record." He turned to me. "Miss Summit, your counsel has made serious claims. Before I rule, I want to hear from you. Do you believe you have evidence of impropriety involving this court?" My legs trembled as I stood, but my voice was steady. "Yes, Your Honor, I do." "And what is the nature of this evidence?" I glanced at my father. For the first time, I saw fear on his face. "I have financial records showing my father paid $75,000 to a consulting firm owned by your son 3 years ago. Property records showing you purchased a vacation home through an LLC partially owned by my father, at a price well below market value. And a timeline showing these transactions coincided with legal cases involving my father's associates that were decided favorably in your courtroom." Silence fell. Judge Whitmore's face drained of color. Those are serious allegations. They're documented facts, I said quietly. I have screenshots, statements, and public filings. I didn't want to bring this forward. I wanted this trial judged on merit. But I can't allow my mother's legacy to be stolen through a corrupt process. Vincent leapt to his feet. Your Honor, this is a desperate attempt to derail the case. These are coincidental transactions. Sit down, counsel, the judge said sharply. Vincent froze. The judge looked at me for a long time, then at my father. Finally, he turned away. We are in recess. I will review this situation. Court will reconvene in 1 hour. He left the bench abruptly. The next hour felt endless. Douglas and I waited in a small conference room. He reviewed his notes while I sat staring at the wall. You did well, he said softly. That took courage. I just told the truth. Truth isn't always safe, he replied. Powerful people don't like being exposed. I thought of my father, his arrogance crumbling. Did he feel regret? Probably not. People like him rarely did. My phone buzzed. A message from the unknown number that had been sending me warnings throughout the case. Helen, I heard what happened. Well done, but be careful. Your father is desperate now. Desperate people are dangerous, I replied quickly. Thank you. Is there more I should know? The response came within minutes. The judge's son's consulting firm is a shell. It exists only to receive bribes. I helped set it up. Your father has been paying the judge's family for years. My pulse quickened. How many payments? At least 8, over $400,000, all disguised as consulting fees. I stared at the screen, stunned. This wasn't bias, it was corruption. Systematic bribery. I showed Douglas the texts. He read them twice, face grave. If this is true, it's criminal. The judge could face disbarment, prison. Your father, too. Is it enough? It's enough to blow this case open. But once we go down this road, there's no going back. It becomes a federal investigation. Your family business will be frozen. Your father will be indicted. Are you ready for that? I thought of my mother on her hospital bed, too weak to stand, telling me to be strong. I thought of her company, her life's work. Yes, I said. I'm ready. When we returned, the air in the courtroom was different. My father looked smaller somehow, drained of his earlier confidence. Vincent whispered frantically to him, but Gregory just stared ahead, jaw clenched. Judge Whitmore entered looking pale, older. After reviewing the situation, he said slowly, I find sufficient concern about potential conflicts of interest to warrant further examination. In the interest of judicial integrity, I am declaring a mistrial. This case will be reassigned to another judge. Vincent jumped up. Your Honor, that's unnecessary. The plaintiff has offered no real proof, only insinuations. The decision is made, counsel. Whitmore cut him off. This trial is over. The reassignment will be issued within 48 hours. He stood to leave, then hesitated. Turning toward me, he said, Miss Summit, I've always conducted myself with integrity. Any suggestion otherwise is deeply offensive. I met his gaze evenly. Your Honor, I have documentation of 8 payments totaling over $400,000 from my father to your son's company over 5 years. If you've acted with integrity, I'm sure an investigation will prove it. His face went white. He opened his mouth, closed it again, and left without another word. My father rose slowly. For the first time since this began, he looked at me not with disdain, but hatred. You have no idea what you've done, he said quietly. I know exactly what I did, I replied. I stopped you from stealing my mother's legacy. He turned and walked out, flanked by his lawyers. I watched him go, feeling nothing but cold resolve. Douglas placed a hand on my shoulder. The hard part isn't over. I know, I said. But for the first time, the truth is out. He nodded. And once truth is out, it doesn't go back in. Outside the courthouse, the wind had picked up, scattering dry leaves across the steps. I stood for a long moment before walking down into the chill morning air, no longer nervous, just steady. Whatever came next, I was ready to face it.